Do you have anything to say, Mr. President?
Yeah. Could you do the same thing for me, Michael?
Sure.
Check.
Testing.
I know, I suppose I'd have my
I
camera
have
on.
regret, but I have one life to give for my country. Wasn't that what somebody said in the beginning of this country, like 1917 something?
Yeah,
so that you'll know, we're going to start off with the speaker, then I'll speak, and then Representative Bishop will speak, and then we'll take your questions.
Well, good morning. We want to thank you for joining us here today. I know these are contentious issues, but I want to say this. We recognize how important it is to have public confidence in our elections today in North Carolina and this nation. You know, North Carolina is the #1 battleground state, and this is an exciting role that we're going to play in this year's election nationally. To prepare for that role, we built one of the most accessible election systems in the United States. North Carolina is actually now the first state to vote. Our citizens actually started casting absentee ballots weeks ago. Over 100,000 North Carolinians have already cast their vote. North Carolina offers no excuse absentee ballot voting. You don't need a reason to request a ballot. You can simply do that, and that's different than many states that actually require you to have a reason for asking it. You know, North Carolina also offers 17 days of early voting. We've nearly doubled early voting by the times, and also allowing the weekend votes. That's almost 3 weeks of early voting in this state. Uniform hours, uniform polling locations have provided North Carolinians and local governments certainty in that process. This year, the legislature passed more elections funding and reforms in the Bipartisan Elections Act of 2020. To address poll worker shortages, we increased their pay to be able to fund and fill those positions. We reformed our absentee ballot laws, funded new online portals, and sent grants to local boards to help with operations. We really rose to the challenge of being the battleground state in the country. Improving our elections builds confidence in our democracy. Due process, the basic rule of law, is critical to that confidence. But that confidence was betrayed by the State Board of Elections. There is no excuse for this type of brazen and partisan act upending our election when it's already underway. When Americans just want a fair process, what could look worse? It's frankly difficult to believe that the governor and the attorney general did this. You know, in May, the Rules Review Commission rejected the Board of Elections' attempts to essentially weaken these laws already. That was shot down, and so the administrative process went through, which is a bipartisan board, rejected that. So it's already been through the administrative process. And what happened? Now the governor's actually suing to disband the Rules Review Commission. This is a board that's been in place to be a check on the governor's authority since the 1980s. You know, a 3-judge panel just upheld the witness requirement this month. Again, bear in mind, these plaintiffs who are suing and these other left-wing groups that keep suing to try to take away the integrity of the election process in this state, they've already been to court trying to get these same things done. And again, they've lost. The 3-judge panel ruled against them. A federal judge in a separate lawsuit also struck down these issues that these same plaintiffs are asking for. This so-called settlement, for example, where they want to get rid of the witness requirement that I know I'll speak about and Senator Berger and Congressman Bishop will talk about. They've already tried several ways to get rid of this witness requirement. And just as an aside, because I know you'll talk about this, Congressman Bishop was elected in a special election because of ballot issues with absentee ballots and the protections that allowed that to be discovered. These folks, this left-wing group filed this, want to get rid of those. And I know you'll talk about that. Just unbelievable the contradiction. So the courts have struck it down. It's been denied by the judicial process. Look, if this so-called consent agreement were a real judicial order based on the merits, we could debate the decision and appeal. But that's not what it is. And by the way, we're parties. Senator Berger and I are parties to that lawsuit. We were never consulted about any of this as parties to this lawsuit. You know, this is not a decision, frankly, by a judge or a lawmaker. This is the governor and the attorney general simply following orders from their Democratic Party bosses in Washington, D.C., who want to do everything and anything they can to try to make this state blue, even though the majority of voters in the state are not that way. This is literally our elected leaders allowing one party's political party's attorneys to rewrite the law. There's no constitutional justification for it. I would call this a sue and settle scam, and it is an absolute disgrace to American due process. I mean, I could only imagine if Senator Berger and I the RNC were to sue us, and you and I were to then, as Republicans, agree to a settlement in this lawsuit to allowing voting by mail or anything else. I mean, the whole notion of it is just completely laughable. No judge has ever heard of this case. No lawmakers had any input in this. It's unbelievable to think that this is actually something that they're really trying to do with a straight face. One interesting thing, the lead attorney for the plaintiffs is a group called the North Carolina Alliance for Retired Americans. The lead attorney for the plaintiffs, Mark Elias, was also Governor Cooper's attorney during his contested recount with Pat McCrory. I want to repeat that again. The attorney for the plaintiffs, who are now suing the state of North Carolina, was actually Governor Cooper's attorney in an elections dispute just 4 years ago. Josh Stein, the Attorney General who's supposed to be defending us, was the keynote speaker at the plaintiffs, the North Carolinas for Retired Americans, at their annual convention. So our attorney for the state was the keynote speaker for this organization back in 2018. Anybody want to guess what the topic was he spoke about? Elections. I don't know what could look worse than that. But this tells us one thing for sure. Democrats are confident that they're going to lose North Carolina based on strong support of the president and of the Republican policies that we have. This brazen attempt to circumvent every conceivable notion of due process in our state government is an act of a desperate party. Knowing their radical agenda will be rejected by North Carolina voters who want jobs and safety instead of the ideas and the things that the Democrats are putting out right now, Democrats, out of desperation, hatched this plan. Look, our state courts are not for fake lawmaking. It is an absolute disgrace that this has happened, and I'll say again what it is. It's a scam. We're confident the federal courts will agree with us. And I'll point this out. We're standing in a room today giving a press statement, and we're going to take questions from those of you here. I think it's interesting that the governor has not stood in a room and actually taken questions from the press in 6 months. But we're here regularly, glad to take these questions, and we'll continue to do so because we want transparency and we want the voters to know the absolute truth of what's happening right now. North Carolinians right now are essentially right before our eyes being mugged of their right to vote this year by the Democrats. They should be ashamed, and we believe the courts will find that this is not proper and will side with us. Thank you.
Good morning. I want to thank you for being here with us this morning. In North Carolina's most recent congressional elections, 2018, the results of one of those races was overturned because of widespread absentee ballot fraud. In that election, ballot harvesters took absentee ballots, tampered with them, and returned them in bulk to the County Board of Elections. That scheme was uncovered because reporters noticed in county logbooks that a few people were dropping off hundreds of ballots. In a near unanimous vote, the General Assembly passed into law added protections to make that kind of widespread absentee ballot fraud easier to root out and harder to execute. And again, a year later, the General Assembly, in another near unanimous vote, modified the election laws to account for issues dealing with COVID-19 and difficulty that might be experienced in voting because of the pandemic. The North Carolina State Board of Elections was involved in this process. In fact, several adopted changes came directly from the North Carolina Board of Elections. But national Democratic activists wanted more. They wanted to dismantle the protections put in place to guard against the very real absentee ballot fraud that plagued North Carolina less than 2 years ago. A federal judge has already rejected those national Democrats' requests to undo ballot protections. A state 3-judge panel has rejected the national Democrats' request to undo ballot protections. A near unanimous General Assembly rejected their request to undo ballot protections. And so after all these losses, the partisan Board of Elections, which is controlled by Democratic Governor Roy Cooper, who is himself a candidate for office, and that board is provided legal advice by Democratic Attorney General Josh Stein, who also is up for election this time. That Board of Elections has employed its option of last resort. They have now unethically colluded with the National Democratic activists to, quote, settle a lawsuit that effectively overturns enacted state law. Other defendants in the case, including the Speaker and me, were kept in the dark while secret negotiations played out. Why? They colluded to permit ballots found in anonymous, unsupervised outdoor drop boxes. They colluded to subvert and effectively eliminate the state law requiring a witness signature on absentee ballots. They colluded to brazenly violate state law by extending the time period in which absentee ballots will be accepted by partisan boards of elections. Democrats on the Board of Elections unethically colluded with their allied plaintiffs to rewrite state election laws after 4 judges and nearly every state legislator already rejected their maneuvering. And they did this while the election is actively underway, while ballots are being distributed, while ballots are being sent in. With these anonymous drop boxes, there will be no record of who is dropping off ballots or where they came from. If this policy had been in place in 2018, it's likely we never would have discovered the widespread absentee ballot fraud that took place. And under this collusive settlement, there will be effectively no witness requirement for absentee ballots. Let me quote you what even a Democratic board member of the Board of Elections said during their closed meeting about this. Quote, "If we say that the voter can cure no witness signature, we are exempting them from the witness requirement. The entire purpose of the witness requirement is to make it more difficult for one person to fraudulently cast ballots for multiple people. By effectively eliminating the witness requirement, the Democrats are inviting fraud. Even their own appointees know this. And here's the brutal reality. Any disputes that arise in implementing these new rules will be settled by brute partisan force. Democrats, appointed by Governor Roy Cooper, control the administration of this election. If this collusive settlement that rewrites state election law in the middle of an election is so non-controversial, why did the Democrats keep it secret from co-defendants? If this collusive settlement is so non-controversial, why were parts of it already rejected by 4 judges? We're witnessing a slow motion mugging of North Carolina's election integrity. We will fight with every tool at our disposal to stop this unethical, collusive settlement. I want to point out the minutes of the closed session of the board that were released this morning. I think if you read through those minutes and if you look at the settlement, what you will see is a couple of things. One, the Democrats on the board understood how important keeping the witness requirement was. Courts had already upheld it, the General Assembly and even the governor had signed legislation calling for it. And so they understood how important that was. Yet what they did and what has happened is the executive director of the Board of Elections has signed on to a settlement of the lawsuit that effectively eliminates that witness requirement. The other thing that I think you should look on page 5 of the minutes. Look on page 9 of the minutes to see exactly what it is the board approved of being settled, and compare that motion and the details of that motion to the details that are in the settlement itself. 3 things are in the motion, and this is what was approved. As it pertains to late return of ballots, that ballots will be accepted if they have a postmark or other indicia of receipt of November 3rd. ballot tracks, commercial carrier tracking info, etc. They need to come back by UDC ABA deadline, close of business on the day before county canvass. The second thing, witness and assistant requirement must remain in effect and in full force, and that the voter himself has the opportunity to cure any deficiencies in voters' attestation or witness portions of container return envelope. The assistant deficiencies may also be cured. Three, no unmanned ballot drop boxes allowed. Maintain log. Clerk asks for name of person returning ballot and verbal acknowledgement of relationship to voter, that they are voter or near relative. Then the clerk writes down CIV number on the log. Then, if person returning is not near relative or voter, clerk will take down name, address, relationship to voter, and then we will accept receipt of the ballot and keep that info available for any investigation. Compare that language to what's actually in the settlement. I question whether or not what the board approved is what is being submitted to the court. I think it's important to look at this as carefully as possible. We've just seen a situation where the executive director has been working for months to get the witness requirement eliminated, working for months to be able to harvest ballots, and this settlement that she has approved effectively does that, and I believe does it in a way that exceeds the authority that was granted to her by the Board of Elections.
I'm Congressman Dan Bishop. Speaker Moore, Senator Berger, thank you for letting me join you in this press conference today. I'm here as a living reminder of that election, Mr. Speaker, that you spoke about. I was elected to Congress after having been a member of the General Assembly. I was elected last year to Congress in September in a special election because the running of the regular cycle election was set aside. It was set aside by the order of the Board of Elections because of a taint that was deemed sufficient to do that, to take that fundamental step of setting aside ballots of 700 some odd thousand voters in North Carolina, and the expense and distraction and time that members of my or constituents in my district were not served because of a tainted election. And what was tainted? A handful of ballots, it was alleged, had been the subject of ballot harvesting. People had handled them inappropriately. Not enough was it ever established to affect the outcome of the election, the number of votes cast, the margin between the parties, but sufficient taint nonetheless. And as both the Speaker and Senator Berger pointed out, it was detected because of those logbooks. And yet now, the Board of Elections, under sharp partisan control, which the governor has striven for and accomplished, advised by lawyers in private, in secret, lawyers from Attorney General Stein's staff, have taken steps, including, as Senator Berger was saying, compare that, what was in the motion, to what's in the settlement agreement. One of those things in the settlement agreement that I'm going to focus on is the fact that even though they say no drop boxes allowed, they also say in the settlement agreement that if ballots are found in a drop box, they're to be counted, to be accepted. Anyone who wants to commit ballot fraud can go see that as a license to go do it as broadly as they want to in any number of elections up and down the ballot throughout North Carolina. How in the world could the Board of Elections arrive at that point just a year, 15 months or so, 18 months after invalidating the result in the election, the 2018 election in the 9th District? Senator Berger or Speaker Moore mentioned that Mark Elias was the lawyer for Roy Cooper in 2016, and he's the lawyer for the parties that have been settled with here, the Democratic plaintiffs. But he also was the lawyer who sought to set aside the result of that 2018 congressional election in the 9th District. I also want to comment just a moment as a lawyer. I was a litigator for 29 years before winning that election in September and going to Congress. And one of the things that I did a lot of was advising bodies, advising corporate bodies and local governmental bodies, as this body was advised by lawyers from the Department of Justice of North Carolina. And I want to point out just two things from these minutes. The minutes are remarkable. I've only had a chance to go through them very briefly this morning. And perhaps they've been released promptly because the board or its lawyers or the AG believe they defend their conduct. In fact, they make it much worse if this is read in detail. One thing on page 7, one of the lawyers from the AG department, Ms. Narasimhan, I don't know how you say her name, she responded to a question from the board. She responded that a judge would have ordered it, talking about the settlement, so it protects the state board from collateral attack. Now, if you're a non-lawyer, you might not know what they're talking about, collateral attack. What they're saying is they want to get a Democrat judge, one, by the way, that has already ruled in a reverse ruling that the General Assembly is a usurper body without full power to act. They're saying they want to get that judge to enter an order because they believe it would be less likely that someone could stop them if they're doing something legally wrong. The other thing that I think worth pointing out about these minutes that I noticed from the very beginning, after the notation of who was in attendance, the very first paragraph following that says this. I'm going to read you 2 paragraphs, and then I'm going to tell you something about it. It says, Chair opened closed session with reminder that the attorney-client privilege and confidentiality of items discussed here are ours as a group and not individual. Reminder to preserve the confidentiality of closed sessions and all issues discussed. That's one of the 2 paragraphs. Stick with me. Second paragraph says, Chair stated that closed session minutes from August 31, 2020 would be approved with a minor correction of the opening statement to include language regarding attorney-client privilege and confidentiality of items discussed. The revised language would apply to all future closed sessions. Chairman Damon Sacosta spent the very first thing he told that assembled board was, you're going to be getting advice from lawyers here in confidence. And you're prohibited from going out individually and deciding to share that with anybody. Who was on that board? For whom was that the message? Let me tell you who. The minority members, the 2 Republicans who were there as the designees of the Republican Party by design. And the advice that was given, I can tell you, is not the law of North Carolina. It is not true that you can bind a party who is on a board as a designee of some other outside group, that they're prohibited from going out and disclosing or sharing with anybody information provided by lawyers in that meeting. Just as these minutes as a whole, in very many ways, show that those 2 board members, as they have subsequently said in their resignations, were intimidated and not fully informed. The very beginning of this set forth with lawyers, these non-lawyers, non-lawyer minority members, lawyers from the Justice Department and from the Board of Elections, and they begin by telling those members, you're under a cone of silence. We're engaged in a process here. We're not going to share it with the legislative leadership who represents the body that passed the law that we're sabotaging. And you can't go say anything about it to anybody. I've never seen a more rank abuse of an attorney's position than that in advising a body. Those are just a couple of points because I know I'll run out your patience to listen to the detail. But we are at the deep in an election season that is one of the most hotly contested and consequential in our nation's history. I can tell you that the Republican members of the North Carolina delegation in Congress are alarmed at what is occurring and certainly encourages the General Assembly's leaders to proceed with every possible remedy in litigation to correct this result. But this, hear me, This is a direct attack on the rule of law, and it must be stopped. One other thing that I'll mention. We have federal elections on this ballot, of course. The President, the United States Senate, members of Congress, and Article 1, Section 4 of the United States Constitution is clear that these elections are to be run according to procedures established not by just anybody, but the legislatures of the several states. And that is what's being sabotaged in the action that we see. You've heard the term several times, collusive settlement. That is not something that just comes out of the air or is the first time that's been thought of. Collusive settlements are recognized in the law in many circumstances. They can come up in tort cases where someone's had a car injury and a couple of parties will get involved to try to get the damages pumped up without the insurance company present. So the insurance company try to bind the insurance company to that. You see it come up in what's called derivative litigation when some shareholder will sue a corporation. And again, you can get a collusive settlement there between the corporation's officers and that plaintiff, and thereby preclude remedy, a substantial and appropriate remedy to all the other shareholders. Collusive settlements have been a problem in the bar for many, many years. This is an egregious one. Here you're using a collusive settlement to settle issues in public litigation, public interest litigation, concerning the force and effectiveness of law enacted by the General Assembly. And it is collusion by members of the executive branch of the opposite party and plaintiffs of that same party as the members of the executive branch. It is an egregious abuse. It is collusive settlements are widely recognized by the bar and the bench to be unethical. And that is exactly what has occurred here. This is a nationwide issue. This election needs to be fair. And this sort of attack on the rule of law cannot be abided. Thank you.
Happy to take your questions.
Senator, Mr. Speaker, Congressman, lots to unpack in what you just said. Let me just start with this. Would you rather there be no settlement and let this play out in court? Because right now you're charging that you don't like the proposed settlement. If there's no settlement, it's not going to make the lawsuit go away. So would you rather play out in court? Is that the other option you want? Or are you pitching that maybe the General Assembly should come back and make some changes to HB 1169, even though it was passed overwhelmingly bipartisan?
The courts should not be utilized to make law and set policy that is contrary to the law and the policy that has been adopted by the General Assembly. And so the courts should, as two courts have already done, should reject this effort on the part of the plaintiffs. So I guess the answer to your question is yes, the cases ought to play out, and there ought to be a result in those cases that basically rejects the effort on the part of the plaintiffs.
Right, because be that as it may, whether it's right or wrong, that the lawsuits have been filed. So I just want to make clear that because you're obviously criticizing the settlement, are you calling on the state to drop the settlement and just play this out in court and argue that the case should be dismissed? Is that what you'd rather have?
Well, we're basically saying that the settlement itself is something that the Board of Elections had no authority to enter into. The settlement itself, the wording of the settlement is actually inconsistent with the motion that was adopted by the Board of Elections, which had no authority to go into that realm to begin with. So this so-called settlement, this collusion, needs to be abandoned by the Board of Elections.
Okay, if the settlement stands and it's challenged in federal court and it stands, will you accept the results then of the election? Or will you challenge, if this settlement stands and it becomes the law or it becomes the rules as is, what does that mean for the election, and what does that mean for the results and the integrity? I mean, are you going to challenge then the results of the election?
So Jonah, if you had asked someone that question in 2018 before the election in 2018, and they had answered your question, yes, we'll accept the results of the election, Would that have been the right answer? It would not have been the right answer. So what I would say is that an election that is fairly and legally conducted, the results will be accepted. Elections that are tainted by fraud, elections that are tainted by inappropriate actions by the Board of Elections will be met with whatever resources can be brought to bear to challenge that.
So are you warning that this settlement would taint that?
I don't think there's any question about that.
Absolutely.
If history is any indication, what this settlement does is it makes it worse in terms of the possibility of absentee ballot fraud than the law we had in 2018. This just invites folks to conduct fraud and makes it nearly undetectable, which challenges and appropriates the vote of every person who follows the law.
And so what's the
I want
message to voters?
to say something, John, on that. And I think it's important to point this out. This is an attack on the voters of North Carolina. This is denying the right to have free and fair elections. The legislation that we passed on an overwhelming, maybe a dozen House Democrats voted against it, passed on an overwhelming basis, made sure that that we could root out voter fraud, which was used as a basis to set aside the congressional election in the 9th District. I mean, this isn't mere theory that people commit elections fraud. I mean, it happens. We had your district, I think, was unrepresented for a full year because of that.
That's right.
I mean, and the expense, the time, everything that's happened on there. And then for some sort of mere partisan advantage, Democrats are willing to throw out basic safeguards. We know they opposed voter ID. That's a discussion for another day. But now basic safeguards to make sure that people are not fraudulently voting by mail. Because Jonah are taking issues that they lost already in open court proceedings. Repeatedly. And now trying some backdoor secret deal to get this done. Every North Carolinian ought to be offended by this. And I think that Governor Cooper and Attorney General Stein need to answer to the people for it.
I have more questions. I'll let my other colleagues get to it. My last one, though, is for this time, please. There's already 1 million absentee ballots that have been requested. That's about one out of every 7 voters in this state. What's your message to them? Are you saying maybe they shouldn't be voting absentee now if they want their vote to count? Are you implying that maybe they should stick with early voting and voting in person?
But I'm saying that every voter should vote in the way that they feel comfortable. Some folks don't feel comfortable going and voting at the polls. They want to vote absentee. But you know what? They ought to be able to feel confident that their vote's going to count, that they're going to be able to have their vote sent in and be counted, and that their vote matters. Actions like what the governor and the attorney general have done undermine that very basic concept.
If I could add to that, Jonah, I don't believe there's any reason to think that the legitimate exercise of the absentee ballot, mailed-in ballot process should be questioned by voters. They can still use that. All of these sabotage efforts go to the question of when someone doesn't follow the rules to send in their absentee ballot. Now, the media have spread a lot of not-sos about this, about what the president has said about absentee balloting. I agree with the president in one respect for sure. Anybody who casts an absentee mailed-in ballot should consult the online resource provided by the Board of Elections to see to it that their ballot's been received and has been counted. They should do that well in advance of Election Day. This is a separate problem. And to the point that the Speaker made and Senator Berger, I'd just like to elaborate on this way. Anytime fraudulent ballots are allowed to flow in and be counted, the people who are disenfranchised are the legitimate voters. Every single time, the vote of a legitimate voter is at least diluted, and if it turns out to be outcome determinative because there's a sufficient number or it's a close race, then all those who voted for the candidate that should have won have all been disenfranchised. You cannot have an election machinery that throws security to the win. And you cannot have voter confidence in the outcome of such an election. And that was exactly the principle that led to the setting aside of the result of the regular election in 2018 in the 9th District.
I've got
Michael.
a couple questions. First, related to having read through the minutes, the two Republican members clearly, they asked questions, they made suggestions about what should be included, what shouldn't, what they support, what they don't. Were they really misled, or did they just make a decision that Republican Party leaders didn't want?
I'd like to take that one first and say the responsibility of lawyers who are advising laypeople is a very important trust. And when lawyers conflate things and say things that are flatly false and fail to report information that is necessary in order to provide those board members a full picture of what they're doing. Like, for example, the fact that there have been, I think, roughly 10 lawsuits filed, depending on how you count, 8 to 10 lawsuits, and every one of them have failed to procure the relief that the plaintiffs here are seeking. That's not mentioned in these minutes. In fact, what these members of the board were told is that it was likely that the judge here was going to sympathize with the plaintiffs. And that was about all they were told about what they should, in terms of how that was going to occur. They certainly weren't advised about whether it was appropriate for an administrative body to supplant the General Assembly's enacted law in what they were doing. So, under the influence of advice from people who arrogate to themselves power, clothe themselves with special knowledge, and then conflate, confuse, and misinform the person who's receiving the information, that taints that result just as cleanly as the taint applied to the election in 2018 in the 9th District. Sorry, gentlemen.
Michael, there are two things to me that are crystal clear from the comments that were made, particularly by former member Black, and that is that he would not agree to anything that did away with the witness requirement. That's one. And two, that he would not agree to anything that would allow an unsupervised ballot drop box. Both of those things are in the consent order. So whether they were misinformed, whether they were deceived, whether they were lied to, the simple fact is the result is not something that the minutes clearly reflect that they would have been in favor of.
One other question related to the drop boxes. So the settlement itself and then the accompanying memo with that, both say the drop boxes would be staffed, and it outlines what the staff members have been supposed to do. So how did you draw the conclusion that they would be unstaffed and not?
I don't have the wording in front of me, but my recollection is that the consent order itself allows for an unsupervised drop box to be available at Board of Elections offices. Maybe it's your understanding that those election officials are there 24 hours a day and will be watching those boxes, but my understanding is that most of them leave either at 5 o'clock or earlier in the evening. And so what do they do with ballots that show up in those boxes overnight? That's one of the more serious questions that is out there that's totally unanswered.
Anybody else?
Okay, John.
All right. So you've been arguing that the settlement gets rid of the witness requirement. In my interpretation of it, it's not exactly what it says. Are you arguing that giving voters an opportunity to cure their ballots negates the witness requirement? Is that the connection?
It's the way they're given an opportunity to cure it. If you look at they call it an affidavit. It's not an affidavit. It's a form that's been created by the Board of Elections for the voter to certify something. But neither, if the voter has a ballot that has not been witnessed, okay, there's no witness on the ballot, there is no requirement of a witness on the certification. So that, in essence, does away completely with the witness requirement. Look at the form that they've generated.
Right. We've reported on those mistakes, missing signatures, missing addresses, and between 97 and 98% of ballots are being accepted, but 2 or 3% of a million votes could still be 30,000, and that could tip the balance, as we saw in something like District 9. What would you want to say is the cure then? If not the affidavit of reform, what would you say is a way to fix that?
The board had already adopted a cure as a result of the order from Judge Osteen, and that cure was basically to communicate directly with the voter, have the voter either vote another ballot with corrected, do away with the original ballot, or come in and fix the problem.
Okay, and the last thing was about following up on Michael's thing about the drop boxes. From my understanding, these are boxes that they're not like in random locations. They're not in front of the mall. They're not in front of, let's say, the state capitol. They're at the county board office, the county board of elections office. And the way it was written said that it says specifically, don't put your thing in here. This is not a Blockbuster return video drop box, but they're not going to reject them solely if they're in the box. Would you rather them just lock the box? Lock the drop box?
They shouldn't have a box that's unsupervised that folks can put ballots in. That's exactly what was happening in 2018. Is one person was putting a bunch of ballots into the board. Now, fortunately, then they had to sign for dropping the ballots off. This would be a situation where a local board comes in one morning, they open that box, there are 50 ballots in there. They don't know where they came from. They don't know if the voters who supposedly are voting are the ones that dropped those off. Are they going to then communicate directly with each one of those voters to confirm that they voted? What if, as Congressman Bishop, I believe it was him that said, what if one of those ballots that's dropped off is of someone that shows up on election day and wants to cast a vote, and they're told, no, you've already voted. And yet the vote that would be considered is one that no one knows for sure where it came from. It is inviting folks to do things to game an election. And quite frankly, if the election's not close, it probably won't make that much difference. But the problem is, y'all are reporting, we are seeing, everybody's talking about how close the election for president is going to be in North Carolina, the election for various other offices, for legislative seats. And so it is critically important that we not have a scheme in place that actually invites folks to try to game the system in a way that gives them a 50 vote or a 75 vote advantage in each county, or even more than that. So that's the thing that I think folks should be most offended by, is that what they're doing is they are eliminating basic protections that actually provide confidence to the people as to the results in the elections. It is critically important. I mean, your question actually, I think, goes to that, your previous question. It's critically important that once election day is over and the ballots have been counted, win or lose, folks agree what the result was. But these are the sorts of things that have the ability of creating uncertainty as to whether or not the result was the right result. Any other questions? Yes.
So maybe you mentioned this already, I missed it, but what happens next? I mean, what are your guys' issue now that this is out here? I mean, are you going to file an appeal? I mean, what happens?
So we're exploring options. My understanding is that the proposed settlement has the judge has scheduled a hearing to consider the settlement. Obviously, our lawyers will make decisions as to what arguments get made regarding that. Whether or not there are other avenues out there, we're in discussions. I can just say that to the extent that there are options available, we intend to explore all reasonable options.
So it's not really clear if there's anything you can do until the judge makes a decision one way or another on the settlement?
No, I'm not necessarily saying that. I'm just saying we've not made a decision as to what we would do, and there are discussions ongoing as to what those options might be. I don't necessarily think that you should wait until, I think it's a week from today, or maybe longer than that. I think something will happen before then. Okay, thank y'all.
Thank you.